Good evening, Lansing School District parents and community members, and welcome to our Parent University session entitled, What is Special Education Mediation and How Can I Help My Student? Provided by Resolution Services. My name is Kyron Harvell, and I'm Director of the STAR Grant. STAR stands for School Transformation Accelerated Results. We're very fortunate to have representatives from Resolution Services tonight who will discuss this topic. During the last 15 minutes of this session, they will be available for any questions you have. Please feel free to place any questions in the Q&A section or in the chat box. Again, thank you guys very much for joining us, and I will turn it over to our representatives from Resolution Services. Thank you.
Hi, everyone. I'm Peg McDougall. I'm the Program Manager for Resolution Services Center here in Lansing. And I want to tell you a little bit about Resolution Services Center, and then we'll talk about Special Education Mediation Services. Resolution Services Center is a conflict resolution organization, and we help people resolve any kind of dispute that you can imagine, from neighborhood disputes to landlord-tenant issues, divorce cases, custody cases, and everything in between. The issue we're going to talk about tonight relates to special education mediation and how it can help both families of special education students and school districts. We provide trained mediators to an organization called Special Education Mediation Services, and you see their information on the screen. And they are an organization that trains our mediators in special education processes, issues, and ways to reach resolution. And so what we want to do today is to talk about how disagreements arise in the special education world and what services are available at no cost to schools and families to help resolve those issues or those disputes. So one of the ways that disputes can arise or disagreements can arise is maybe because not everybody has all the information necessary to help make decisions. Sometimes it's a lack of communication between the parties. One party thinks something is being done a certain way and the other party thinks it's being done a different way. Sometimes there are misconceptions or misperceptions about how people are interacting or how services are being carried out. And sometimes there are different points of view about how services should be carried out. In the special education world, students with special education needs generally have what's called an IEP, an individualized education plan. And that plan sets out what special types of services students are going to receive who have the IEP. And in order to get an IEP, the school district and the parents go through a process to determine whether or not the student is eligible, for those services. And every year there is a review of the IEP, and sometimes more often, to figure out if the services being provided are still appropriate, if they need to be tweaked in some way, or if other services need to be added or subtracted from what the student is receiving. And so part of what the Special Education Mediation Service does is to provide neutral third parties who are called mediators or facilitators to help with that process of the IEP, and also to help with a resolution of a dispute that the parents may have with the school district about either how services are being delivered or what services should be delivered. And so our goal tonight is to talk about what those disagreements can be and what the process of using a mediator or a facilitator looks like, and how those neutral third-party mediators and facilitators can help parents and school districts reach resolutions to continue the advancement of the education process of the child. Part of what we do in both mediation and facilitation is to help the parties create and maintain open lines of communication. Because when people are able to talk and communicate about issues that concern them, it always leads to a better understanding of of problems and concerns, and it helps keep the focus on the child who needs the special education services. Some of those discussions can be done collaboratively through direct talking between the parties, through what are called facilitated meetings and what are called mediations. And let me talk a little bit about what the difference is between a facilitation and a mediation, and then we'll talk about the roles of the mediator and the facilitator. A facilitator is a person who helps manage a discussion of a large group. And they generally do that when there's not a specific issue or dispute to resolve, but when there just needs to be a general conversation about something. So in the special education world, the way that works is that the facilitator is often brought in for the IEP meeting. And the facilitator's role, again, is to be a neutral third party, but to help the parties have a discussion, keep the meeting on track, both in terms of the subject matter and the time element involved, and also to keep the focus on the student who needs the special education services. A mediation is a little bit different, and a person who is a mediator has a few different roles, and we'll talk about those as well. But the basic understanding of a mediator's role is that they are a neutral third party, and they help the school and the families talk about issues of specific concern. So for instance, if a parent or a family member thinks that a service should be being provided but is not, that's a specific issue that the mediator would help everyone have a discussion about and talk about what options might be available to address that concern. Again, if a family member thinks they'd like a particular service provided, the mediator can help manage that discussion and help the parties talk about options that are available and concerns that everyone has with regard to that issue. And again, we'll talk about the mediator and facilitator's role in a little bit more detail. So the role of both the facilitator and the mediator are to manage complex meetings and complex discussions and complex issues. They also help to resolve any disagreements that the parties may have, and they help to resolve communication between the parties. Because once the parties are able to open up the lines of communication and keep the focus on the needs of the student, then they're much more likely to be able to find common ground and reach a resolution. So as you see on the screen, mediation is an assisted negotiation to resolve differences conducted by an impartial party. Facilitation is coordinating a discussion so that all group members are encouraged to participate. Both of these processes are voluntary, which means that the family and the school both have to agree to have the neutral mediator or the neutral facilitator come in and attend a meeting. The goal of mediation is to resolve a specific dispute. As I mentioned before, and gave you a couple of examples. The mediator establishes the process. The people who disagree with what's going on are the ones who attend the meeting, and the mediator must be neutral. Mediator doesn't take sides, doesn't tell either side that they're right or wrong, doesn't decide what the facts are, and the mediator does not impose a solution on anyone. If a resolution is reached at the mediation, it's solely because the parties themselves have created their own solution to the problem. Facilitation, again, is a little bit different. The goals of the process are to complete the process of the meeting efficiently and collaboratively. Generally, the school establishes the process, and they will often run that facilitated meeting, although very often they would like the facilitator to do that so that the school can then be an active participant, separate and apart from running the meeting. Who attends that facilitation? Generally, it's the special education team members or some group of the team members. And again, the facilitator acts as a neutral party. They don't impose a solution on anyone, and they don't take sides in the mediation. So when do you use the facilitation? So I mentioned already the IEP meetings, IFSP meetings, MDR meetings, and some of you may have had involvement with those. All of those circumstances are situations where a neutral facilitator can be brought in. Resolution sessions that are involving your special education students. Sometimes participants are just uneasy about a meeting and they would like a neutral third party to kind of run the meeting and make sure that everybody's concerns are heard. And that's another appropriate time for a facilitator to be involved. Sometimes the family and the school have strained relations for a variety of reasons. And so sometimes it really is very helpful for a neutral third party to attend the meeting, conduct the meeting, and that allows the family and the school personnel to be active participants and collaborators in trying to reach a resolution for the needs of the student. And then when participants need to focus on issues, and again, that allows the parties to focus on the content of the meeting rather than on the process of the meeting itself and what's the timeline and are we complying with the timeline. So again, it allows them to be active participants. So what will the facilitator do in a meeting regarding a special education student? So the facilitator will receive all the case information that's gathered through the intake process. And I'll talk about how to get involved in the intake process as we get toward the end of our discussion. But basically, anybody can contact the Special Education Mediation Services office or our office, and we will provide information about the process and gather information from you, whether you are the family member or a representative of the school. We will gather that information about what the situation is all about, and that information will be shared with the person who is going to facilitate the meeting. The facilitator will acknowledge the review of an agenda, understanding, and meeting guidelines that are put in place so that everyone has an opportunity to express their perspectives. Again, the facilitator will stay neutral and will make sure that everyone abides by the rules for appropriate conduct in the meeting, whether that meeting is done virtually or in person, and meetings are being done both ways right now. The facilitators, one of the facilitators' primary goals is to keep the meeting centered on the student's needs and to keep the focus on the student and how best to meet the student's needs. The facilitator will help negotiate any disagreements about services that might be provided to the student or that the family is requesting be provided to the student. As part of that, the role of the facilitator is to ask questions of all participants to clarify issues and concerns and help everyone develop ideas and options for meeting the student's needs. The facilitator will also keep the meeting on track so that the main issues are focused on, and will keep track of the time so that everyone's time constraints are respected in the meeting. And finally, as I mentioned, the facilitator will conduct the meeting if requested to do so by the school district. Otherwise, the school district will generally run the meeting, and the facilitator, again, may be asking questions to clarify issues or concerns, or to step in and provide help with negotiating disagreements that may arise during the course of the meeting. What the facilitator won't do, and this is really important, the facilitator is not considered a part of the special education team, all right? They are the neutral outside third party who is there to help facilitate communication. They will not give legal advice. The facilitator may be an attorney by training, but they are not there to represent either the school district or the family or the student, and they will not give legal advice. They will not advocate for a position or a party. And so that means that while they may ask complex questions and important questions, they are not advocating for a party or a position when they do that. They are asking questions to clarify issues and concerns that they have heard from the parties in the discussion. And they will not make decisions or impose decisions on anyone, excuse me, who is participating in the process. The decision making is left squarely in the hands of the family and the school to make those decisions. And the Department of Education, Michigan Department of Education, encourages these types of processes because they want those decisions to be made as close to the student as possible. And they believe that the families and the schools know best what is appropriate for that student. And so they want those decisions, if possible, to be made by the team, which is the families and the school representatives. And so the facilitator will not make decisions or impose solutions on anyone who participates in the process. Let's talk about mediation a minute and how it differs from facilitation. So mediation can be used when there is any special education dispute, such as eligibility for programs and services, evaluation interpretations, transition or discipline issues, service delivery or effectiveness. And by that I mean, again, if a parent thinks the service should be delivered and believes it is not being delivered, then there can be a discussion about that. Or if they believe that a service that is being delivered is not being delivered appropriately, there can be a mediation about that. Lots of other issues along those lines, but that's kind of the general idea. Mediations can take place in lieu of resolution sessions, and the goal of the mediation is communication improvement and relationship issue improvement, and reaching a resolution on specific disputes that may exist in regard to delivery or eligibility of services. So what will the mediator do as opposed to the facilitator? You're going to see some things that look the same, and you're going to see some things that look a little different. So the mediator, again, will remain neutral. They won't take sides. They won't decide who's right or who's wrong. They won't decide what the facts are, and they won't impose a solution on anyone. They will remain neutral. They conduct the mediation. It is the mediator's process, and they will set ground rules about how that process is going to go forward. But they are in charge of the process. The parties are in charge of the outcome. So the parties will reach a resolution on their own or not without a resolution being imposed by the mediator. They will ensure that all the parties have an equal opportunity to express their ideas and thoughts and express their concerns and talk about them. Again, the mediator will ask questions to clarify issues and concerns and to help the parties find common ground and generate ideas and options for potential solutions. They will make sure that everyone abides by the rules for appropriate conduct, just like a facilitator does. They will help the parties stay on the topic of their disagreement. And whereas in a facilitation, there may be many issues discussed related to an IEP or services that are being proposed. In a mediation, there generally are one or two or a handful of concerns or issues. And so part of the role of the mediator is to help the parties stay on the topic of those specific disagreements and guide the parties toward creating an agreement. Now, that doesn't mean that the mediator tells the parties what to do or has preconceived ideas about what the resolution should be. But again, the mediator will be asking questions to clarify issues and the concerns of the parties, with the idea that that will help the parties sort out options and ideas that can be implemented for the benefit of the special education student. If there is an agreement reached on any of these issues, the mediator will transcribe, write up the mediation agreement. Now, there are many ways that agreements can come about. There could be what's called a full agreement, meaning all the issues that were of concern were resolved. So let's talk about the benefits of mediation in addition to what I've already talked about. So mediation, again, like facilitation, is voluntary. The family and the school have to agree to come together and have a mediator come to talk with them and help them try to resolve a matter. So it's voluntary. It's confidential, all right, which is wonderful. The participants control the outcome. I talked a little bit about that already. There is a written binding agreement between the parties once an agreement is reached. It helps the participants become more self-sufficient in creating their own solutions to the dispute. The solutions remain local, and by that I mean that the parties are able to reach a solution that works in their setting, in their school, with that particular student. And the Michigan Department of Education, Office of Special Education, promotes mediation because they want those solutions to stay local. They would prefer that families and schools resolve those issues so that there are not state complaints filed and due process complaints filed, because once that happens, then somebody outside the local school district is going to take a look at things and make a decision and impose solutions on families and schools. And so they encourage mediation and problem solving at the local level between the families and the school districts. There's a cost decline in dispute resolution, all right? So it is much more cost effective for everyone to come together and sit down and mediate a case, because there is no cost for the mediation process. And I'll talk about where that funding comes from toward the end of our discussion. So if there's less money being spent on dispute resolution by families and schools, more time and more money can be spent on education. And so that's a benefit to families and schools and students themselves. So I wanted to talk about how to access these services. So you can call the number that appears on your screen, which is 833-KIDS-FIRST, which is 833-543-7178. Or you can complete a service request form at the website that you see on the screen. What happens at that point is an intake specialist from the Special Education Mediation Services program will contact you to get more information. And this contact applies for both schools and families. They can both call or contact through the website. The intake specialist will contact you and will get more information about the situation, and they will then contact the other party, whether it's the parent or the school, to explain the process and to see if they are interested in mediation or facilitation, and explain what options are available. Again, they are not able to give legal advice, but they will explain the mediation and facilitation process. If both parties agree to have a facilitator at a meeting or they need a mediator, then the SEMS, the Special Education Mediation Services, will contact my office, Resolution Services Center, or other offices like ours around the state. This is a statewide program. And they will say, we have a case. Here's the information about the family. Here's the information about the school. And we will then, from our office or the other dispute resolution offices in the state, contact the parties involved to schedule a date if it has not already been scheduled. We will then provide one of our trained mediators who are trained both in the mediation process in general, but are also trained in special education issues and processes. And we will arrange for one of them to attend the meeting, either virtually or in person. And they will get copies of intake information that has been provided by the family and the school district. And once the meeting is over, they will then provide us with information about the outcome of the meeting, and participants will be emailed evaluations to complete about the process, or if the meeting is done in person, generally the mediator or facilitator will hand those out at the meeting and ask participants to complete those and return them so that we can have a measure to track the satisfaction of the process and the mediator. So let me talk a little bit about the myths of mediation. And one of the big myths of mediation is that it undermines the decision-making authority of the parties. And I talked about that a little bit already, but the bottom line is that the parties remain the decision makers in all mediations. The mediator cannot decide the issues for them. And so this process actually provides more control for the parties than less control. And it helps them take control of a solution to the issues that have been raised. The second myth of mediation is that if there has to be a mediation, that's because the school district has failed in some way. That is far from the truth. The Office of Special Education is aware that sometimes there are disputes in the special education world. Sometimes that comes just merely from cross-communication between the parties. The Office of Special Education is mainly concerned with how those disputes will be resolved. And they favor resolution among the parties first through direct talks or mediation. And they do this because, again, they believe that the best resolution is a local resolution. The information that goes back to the Office of Special Education is data in aggregate only, all right? So the information about whether an issue was settled or not settled, SEMS provides that information without names and only, again, as aggregate data, so that again, there's confidentiality and anonymity so that the parties can feel free to fully participate in the process. Again, the myth that mediators and facilitators are or should be advocates, and we talked about that a little bit. The mediator and facilitator walk a fine line to balance the discussion between the school and the family. And their role is not to advocate, but to have the parties have that discussion so that solutions become easier to reach, not harder to reach. And again, we've talked about the myth of providing legal advice. The IDEA, requires that mediators be knowledgeable, but not expert in special education law. So voicing a legal opinion, even if accurate, could be seen as bias in favor of one party or another. And so mediators and facilitators will not be giving legal advice. And so it's important for everyone to know that going in. Families are allowed to bring advocates to facilitations and mediations so that they have someone, if they feel it necessary, to act as their advocate, because the mediator or facilitator will not fulfill that role. So attorneys and advocates do have a role in the mediation process, and attorneys and advocates can participate in the mediation to support the parties and the process. Again, this is another contact information page. The services, you see the number there, 1-833-543-7178. The website is mikidsfirst.org. And if you wish to contact our office, which is Resolution Services Center of Central Michigan, you have our address right there, 516 South Kreitz, Suite A, Lansing, 48917. And our phone number is 517-334-0034. And there is an email, info@mikidsfirst.org. So I want to talk a little bit about how the special education mediation program is funded and why that's of benefit to the families. So the Special Education Mediation Services Office is a grant-funded initiative of the Michigan Department of Education, Office of Special Education. And the benefit of that is that they are able to offer free mediation, free IEP facilitation, and collaborative communication training to schools and parents across Michigan. So as I said, this is a statewide program. Any family who has a special education student or is seeking to qualify a student for special education services, and any school in the state can contact Special Education Mediation Services for assistance at no charge to the families or the schools. And the benefit is that the process promotes student-first focus. And over 3,500 students, families, and schools have been aided in this process since its inception in 1997. It fosters cooperation among families and schools and effective teamwork among those who plan education services for special education students. And it's a free source for improving communication and resolving disputes between the parties. I think, as a mediator myself and a special education mediator, I think one of the biggest benefits I have seen in special education mediations is that it helps the parties clear up maybe some confusion that they have had about how other people in the process are operating. And I say that because even in cases where there might not be a mediated agreement, invariably, families and school personnel will say to me, this was a worthwhile process. I learned some things about the other participants that I didn't know before. I learned some interesting things about the parents' concern. I learned some interesting things about the school's activities with regard to my child that I did not know before. And anytime you can open up those lines of communication, I think that the benefit always goes to the child, because it helps people be more willing to share their concerns and their ideas for solutions when they can open up those lines of communication and express their concerns and their ideas for solutions. Because, you know, the old saying is, you know, 2 heads are better than 1. Well, if you've got a group of 12 people at the table, 12 heads are usually better than 1 trying to come up with solutions to help students. And I always suggest to people that, since special education services generally have to be provided through the age of 26, if you have a child diagnosed with special education needs, say at the age of 5, you have 21 years where you as the school district, you as the parent, are going to be needing to work together to provide services to the student. And if you can open up those lines of communication early, then you're much more likely to be able to work together and address concerns as they arise. Now, that doesn't mean that you'll always agree, but it does mean that if you're able to express your views openly, you're much more likely to reach agreement than not. And so the benefit is always going to inure to the student if you're able to do that. And isn't it better to be able to walk away and say, well, I disagree with that perspective, but I've heard it and I've been able to respond to it. And knowing that you can do that builds relationships between families and schools and students in a way that is beneficial at every step of the way in all of the years that you're going to be communicating with each other. The other thing I always suggest to families and schools when I talk with them about these types of cases is that while you all have legal options that you can pursue if you choose to do that, the problem with choosing a legal option is that you no longer have control over the outcome. You have given that control to a third party. So there will be a judge somewhere who ultimately, unless you reach an agreement on your own, that judge will make a decision and will impose a solution on everyone. And that may be a decision that nobody likes. It may be a decision that people think is not in the best interest of the student. Whereas if you pursue the mediation process, you don't give up any of your rights to go the legal court-oriented process or administrative law process, but you create the possibility of reaching your own solution that you contribute to, that you have some control over, and that you can say, my concerns were heard and I contributed to the solution that we're going to pursue to help this student. And so again, it's a process where you have much more control over the outcome than if you address your concerns through the litigation process. The other types of situations where mediation is appropriate is when there are state complaints or due process complaints. Mediation can be used then and can be requested upon the filing of a complaint. And parties in that type of mediation where there is a pending complaint can ask that complaint timelines be suspended pending the mediation outcome. And issues that are resolved in the mediation can then be dropped from the complaint. And again, if not all of the issues are resolved, then the issues in the complaint that were not resolved would continue forward. And complaints resolved in mediation can be withdrawn. And so that's another area where mediation can be beneficial to help the parties reach a resolution, short of actually having a solution imposed on them by a court or an administrative law judge. I want to put on our screen a thank you to all of the folks at Special Education Mediation Services who provide these services to us. Cheryl Levine is the project coordinator. Laura Zangera is the intake coordinator. And then Diane Koulis is intake specialist. And then we have outreach representatives who do outreach around the state to provide information about these services. As a mediator for, I guess, going on 14 years now, I just want to say that mediation is a wonderful process to open up lines of communication, to help parties collaborate and work as a team trying to reach a resolution that works for everybody, finding common ground, finding solutions, finding out information about each other as they operate to provide services to the special education student. And when those things happen and there's better communication, there's much more likelihood that there's going to be a resolution of the dispute in a way that everyone accepts and moves forward with the focus on the student. So I want to thank you for this opportunity to present this information. And if anyone has any questions, I'd be happy to answer questions.
Thank you very much, Ms. McDougall, for that amazing presentation. I have a question, actually. What role do you see our school administrators playing in terms of making the referral? Should this be based on something that administrators are witnessing among students, or should it be a situation where you wait for students to possibly, to bring it to you? What are your thoughts about that?
So I think those kinds of situations can happen either way. We have a very good working relationship with the schools in the mid-Michigan area, and special education directors and student services directors, other folks in those positions routinely call the SEMS office or call me directly and say, hey, we have a situation. Is that something that you folks could mediate for us? What do you think about that? And we will be happy to move forward with that. So most of the cases right now come from the administration in the various schools and from family members, parents, guardians, and occasionally teachers will reach out, but they generally have already talked to their special ed director, and they're moving toward asking for a mediation. But we welcome calls from school personnel about moving these issues along, and I think we have a good relationship with them.
Great, thank you very much. Again, we'd like to thank the representatives from Resolution Services. Phenomenal presentation. This session has been recorded and will be placed on the Office of School Culture website under the Parent Diversity section. Please join us this Wednesday when Technology Director Jeff Vanderlaan will present on cyberbullying and technology safety. Any closing words, Ms. McDougall, for our participants?
I encourage people to use mediation, because even if there is not an agreement reached, it's amazing how that helps create a better relationship between all of the parties moving forward, because now they know they can communicate openly. Great.
Thank you very much. Again, thank you to all of our Lansing School District family for taking part in this event. And we appreciate you. Special thanks to Resolution Services. We appreciate your support. And I hope to see everyone on Wednesday. Have a good evening.
Thank you.